Mr. Strickling, I want to focus right now on questions of compliance with federal law. If Congress passes an appropriation rider this month mandating that NTIA renew the contract with ICANN, will you commit that NTIA will comply with that mandate?
We will follow your direction, sir.
So you are aware, and that means you will renew the contract if that's mandated.
If that's what we are told to do and that passes Congress, we will do that. And we have taken the preparatory steps to allow us to do that as late as the night of September 30th, if it comes to that.
Now, you are aware that Section 539A of the Consolidated Appropriation Act already makes clear that, quote, none of the funds made available by this act may be used to relinquish the responsibility of the National Telecommunications and Information Administration during fiscal year 2016 with respect to Internet domain name functions, including responsibility with respect to the authoritative root zone file and the Internet assigned numbers authority functions. That is existing federal law.
That's correct.
Passed by Congress and signed by the President.
That's correct. And I have followed that as well as all members of my staff.
So it is your testimony you have followed this?
Absolutely.
That you have, and you're aware that when an appropriation rider says none of the funds may be spent carrying out a function, that means not only dollars, that means time of government employees.
Right. I have done nothing to relinquish the responsibility of NTIA with respect to the Internet domain name system during this fiscal year.
So it's my understanding that the NTIA awarded a contract in the amount of $18,690 to the Berkman Center at Harvard University to study the transition plan. Is that correct?
We asked for corporate governance expertise. That's correct.
It's my understanding that the NTIA paid Professor Brackman Reiser $9,207 to conduct a review of the transition plan.
That sounds correct, yes. We absolutely retained her.
It is my understanding that the NTIA incurred expenses of $1,658 for 2 meetings in New York with experts relating solely to the transition. Is that correct?
We had 2 meetings in New York. I don't remember the precise dollar amount, but that sounds right.
And you have used government salaried staff time to conduct a review of the transition and to prepare and draft the IANA Stewardship Transition Proposal Assessment Report. Is that correct?
Just as Congress directed us to, yes, sir.
You're also aware of the terms of the Federal Anti-Deficiency Act, also federal law, which provides that it is a criminal offense punishable by up to 2 years in prison and a $5,000 fine if an officer of the government knowingly and willfully makes or authorizes an expenditure or an obligation exceeding an amount available in an appropriation or fund for the expenditure of the obligation. Are you aware of that?
I'm aware of the Anti-Deficiency Act, yes, sir.
How would you explain to this committee, does your conduct, the expenditures we went through, all working to relinquish the control of the Internet? How is that consistent with federal law and the Anti-Deficiency Act?
Well, you've just added a word that's not in the rider. You added working to relinquish responsibility. I have not relinquished any responsibility. But the provision does not reach preparatory activities, and indeed Congress expected us to engage in preparatory activities because at the time the first rider was passed in 2014, we were directed to conduct a thorough review of any transition plan that we received. So Congress understood that during the pendency of that rider that we would be engaged in activities preparing for the transition, but those themselves do not relinquish any responsibility.
Do you have an Office of Legal Counsel opinion stating that, as you put it, preparatory functions are not included in this rider?
We were so advised.
Do you have a written opinion from OLC to that effect?
I have it from my Office of General Counsel at the Department of Commerce.
I would ask you to submit that legal advice to this committee.
I understand. I will take that back.
But you do not have an opinion from the Office of Legal Counsel of the United States Department of Justice to that effect?
I'm not aware of one, no.
I would point out that under your interpretation, which I consider to be tortured interpretation of this statutory language and unfaithful to the text, and let's go to the other one, to the actual rider. Your interpretation is preparatory conduct is not encompassed in this, so that the Commerce Department can do absolutely everything required to relinquish the Internet, the responsibility, right up until the moment of pushing the button.
Well, sir, I'm sorry.
Your position is every single act of preparation can be done, and as long as it actually hasn't been culminated with the relinquishment, that is perfectly okay. I'm going to say two things. Number one, I'm going to ask you, if that interpretation is right, why on earth would Congress pass this? This is a meaningless rider. If your interpretation is right, what the heck is Congress prohibiting?
They have prohibited us from relinquishing responsibility. But let me ask you this, Senator. What is the responsibility referred to there? The only responsibility that we have is not based on any statutory obligation.
Mr. Strickling, I understand.
Let me finish, Senator, if I may.
Understand.
Senator, if I may finish.
No, you may not. You may answer my questions.
I'm telling you that the responsibility we have has been to privatize the domain name system.
I understand that you have a political mandate to do that.
But
let me be very clear. The fact that you disagree with the policy judgment of the Congress of the United States as reflected by federal law, you're entitled to disagree with it. Here's what you're not entitled to do, sir. And I want to speak for a moment to the employees who work for you, to the government employees at the NTIA and at the Department of Commerce. These legal prohibitions have been passed into law by Congress and signed by the President. If your political superiors instruct you to proceed with this transition, to spend your time, to spend 1 penny of government money, you have an obligation as an employee of the federal government to decline to follow that instruction, to violate federal law. And let me note for you, if you don't, if your superiors direct you to do it and you carry out those orders under the Anti-Deficiency Act, you are risking personal criminal liability of up to 2 years in prison. And I would note, this administration that has politically mandated handing over oversight of the Internet, this administration is not going to prosecute anyone. But in January of 2017, a new administration will be in Washington. We don't know who that will be, but I am advising the employees of the Department of Commerce, your political superiors do not have the authority to instruct you to violate federal law, to violate what Congress has passed. Mr. Strickling has told us he disagrees with Congress. He's entitled to disagree with Congress. He is not entitled to instruct federal employees to violate federal law. And each of you should be on notice who has worked hard to have long, distinguished careers that political appointees of this administration cannot instruct you to violate federal law.
Senator, we have followed the law. We have not relinquished our responsibility. I am outraged that you are accusing us of doing that, especially when the very conduct that you raised, if I may read to you, the committee directs NTIA to conduct a thorough review and analysis of any proposed transition of the IANA contract. We were directed to do that as part of the spending bill that was passed for fiscal year 2015. It carried forward in fiscal year 2016. So it's clear that Congress never intended to relinquish the responsibility to mean all of the preparatory activities we are engaged in, because we were directed specifically to conduct a review of the plan.
Mr. Strickling, a committee report cannot change clear statutory text. And you, under your interpretation, which I consider not a reasonable interpretation of federal law, because it renders federal law absurd and meaningless. Under your interpretation, this rider had no effect whatsoever. And for those federal employees working for you, they need to make a determination. Are they willing to risk their own careers based on what I believe to be a political interpretation? I hope the answer to that is no. Congress has the authority to make this determination, and you are welcome to disagree with it, but you are not welcome to disobey federal law passed by Congress.
I have not disobeyed any federal law with respect to this.
Senator Coons.
Thank you, Mr. Chairman.